So, good afternoon, everybody. My name is Deborah Oppenheimer, and I am one of the partners here at Altitude Community Law. So, we're going to talk about harassment today. What is it? When's it actionable? I'm sure if you've been in the industry for any amount of time, you've certainly had board members accuse homeowners of harassing them, and many homeowners of accuse the HOA of harassing. So we're going to talk about it a little. As usual, in all my slides, I'd like to remind everybody where you can find all this stuff on our website. And a reminder that these webinars are in fact taped. So you can go to our website and catch this later if you missed it today or want to go see it again or want to show it off to somebody else. Right now, you should see the PowerPoint taking up most of the screen. You should see me on a small box on the left-hand side. On the right-hand side of the menu, you should see a private chat icon. Use that icon to type in questions, and I'll try to address them at the end of the webinar if I don't get time during the webinar. If you have any audio or video issues during the presentation, click the no audio or video button. It should be below the presentation on your screen, and it should give you instructions on how to correct it. This class will grant you one CMCA credit. It's automatically generated and emailed to you after the webinar, assuming you attended the entire program. The credits are not transferable. Please email Jessa Ledesma at jledesma@altitude.law if you have any questions, or call her. Her number is 303-991-2086 if you have questions about the webinar or getting your credits. Lastly, at the end of this, there's a survey. We encourage you to take it and tell us what you think, because we do try and change our presentations, and we do listen to the opinions, and they're very important to us. So moving along. So when we look at harassment and you start thinking about harassment, I mean, what most of us think of as what's harassing to us is probably the Webster definition, right? If we're annoyed, if somebody, siblings are the easiest, one child harassing the other child. Obviously, it becomes a little more different if it's hostile. And hostile harassment often is what you end up with in the courts. And there is criminal harassment, right? There's the criminal statute that we have in Colorado. This has been revised multiple times, so you see sections that say completely repealed. But what we often see as harassment when we're talking board members getting harassed or one homeowner harassing another is what is in Section E, right? Initiating communication with a person, directing language towards a person, anonymous, by telephone, that either threaten or are intended to harass, right? And, often we, when I used to be a district attorney, we would see a lot of F, which is using the phone to harass somebody. Honestly, we have certain homeowners who, are challenging them repeatedly. The problem being is what is harassment versus a legitimate expression of a homeowner displeased with the actions of their board member and trying to communicate that, right? Where's that line between legitimate versus harassment? When we talk about courts and we're talking about what is, civil harassment that is in a court case, that's generally talking about sexual harassment or maybe discriminatory harassment or workplace harassment. Okay, so those are really kind of the harassments that the court takes on when it's a civil case and you're saying, that person was harassing me and I want to sue them for it. It's not normally the harassment that our board members are talking about or our homeowners are talking about. When we think about it, we need to think about and focus on what is legally harassment in the HOA. So you've probably seen this slide from me 100 times, but you always have to start here, which is the purpose of the association. And in olden years, the purpose of the association was really just to enforce covenants, and covenants legal definition is something that touches and concerns the land, right? Well, harassment really generally is not going to touch and concern the land. It's really not going to be a covenant. It's that second bullet here, which is promoting harmonious community living. That harmonious community living is going to be when you get that issue of harassment, right? And sometimes when we get these calls, the answer is going to be, not my job, man. And you're going to love that, because you're going to say back to the homeowner, this is not covenant enforcement. This is not what an HOA's purpose is about. This is something you need to talk to the police about. Okay. And so we're going to try and go through some of these situations. Obviously, managers, so much of your job is the harassment of owners, right? They're harassing you. Could you do this? Could you do that? Could you fix this? Could you make my neighbor be nice? Could you make my neighbor do this? Could you make my neighbor do that? And unfortunately, it's not going to fit the legal definition. Unfortunately, a lot of time it's going to come under your job description of taking those calls. Obviously, there becomes a point at which it exceeds your job description, and we'll kind of talk about that. But a lot of the harassment you get as a manager is your job, and I'm sorry. And I get that too, because I do covenant enforcement, and so you get to dump that on me sometimes, and then I get to be the one who gets harassed by the owners. But a lot of that happens. Board members don't understand that homeowners have the legal right and ability to complain about them. You know, just like we as citizens in the United States have a right to complain about our legal representation. And we can call our senator up and say, you know, what you voted on, you're so stupid, this is wrong, right? We can say that. We're legally allowed. And homeowners have that right to board members, right? They can call them up and say, are you kidding me? Why did you hire that landscaper? He's clearly incompetent. Have you seen how terrible our landscaping looks? And that feels really awful to the board members, and they don't like it. And they feel very much harassed. And unfortunately, that's part of their job. When they got elected, they have to take those calls. And they're not fun calls, and they're not fun emails. And it strikes a chord, and it's not a pleasant call, but it doesn't rise to the level of legal harassment simply because they're saying, I don't like what you did. I don't like who you voted in. I don't like, you know, what you voted or agreed or what contract you signed. That's wrong. But that is part of their job, right? And so that's something they have to deal with. Okay, what about owners harassing other owners? That is a big one. And that's one that often they want the manager or the board members to fix. And that's a lot of the big ones that you're going to get to say, not mine. Owners harassing vendors, completely out of their purview, completely a violation of your contract rights with that vendor, and something that you can take action on. And we'll touch on that. Sometimes we have a manager or a board member who's accused of harassing the owners. And most of the times those come in because the manager or the board member are enforcing covenants, and owners don't like to be told what to do. And because the owners are being told what to do, they're instantly going to redirect it and go, you're harassing me, because they're being told they have to comply with the covenants. And that's a frequent one that is the cause of a claim of harassment, but it's not harassment. You know, so when owners are harassing the manager or board member, right? Snail mail really kind of delayed that kind of contact, right? It took time to write out a letter, even type out a letter, and then mail it. It took a long time. And so most owners probably didn't go through the effort as much. It wasn't that worth that much time and effort to them. But nowadays, with email and text messaging and social networks, it is easy as can be to troll the manager, right? To write that long email about how they don't like anything that's happening, and they don't like the covenants, and they don't like how you look, and they don't like what you're doing, and they don't think you're doing your job right. And it becomes something that's very simple for them to sit in the privacy of their home, not be responsive, not even half the time signing it, have some made up name on their email. You don't even know who it came from, and they don't sign it, and it's rude. So first and foremost, if that email isn't signed, it's anonymous, block it. You got no responsibility whatsoever to take that email. Throw it away in the trash. You don't have to take it. If they are signing it and they're doing it repeatedly. So the question is, how many does it take repeated emails before it's harassment, right? So if you go back to that definition and it talks about that it's repeated communications, right? How many repeats does it take before you can say, hey, this is harassment, and turn it over to the cops? And I will tell you that that's going to depend on what cop arrives on your doorstep when you call it in. It's also going to depend what the content of the email is. If the email in any way says, I'd like to kick your ass, that's a threat. And that's going to come to the top of the line, and it's only going to take that one threat before the cops are going to be willing to do something about it. They might not be willing to go file charges, but almost any time there's I'm going to kick your ass kind of communication in an email, the cops will be willing to go talk to that homeowner. So if you know, and you can connect the email to the homeowner and the address and give it to the cops, any threat of any kind, you're going to be able to move it along and send it off to the cops. All right. If there's no threats in it, how many does it take? Well, one a day is going to make it annoying to you, but it's probably not going to be annoying to a cop. Multiple in a day, I think would rise to the level that you would get a cop to take action on it, even if there's no threats, because it's just a huge harassment of you. It's clearly not meant to achieve anything. It's just meant to annoy you, right? And so the first thing I always recommend when you start getting those emails like that is remind the homeowner, you're one of 250 homes in this community. And I can't answer an email from you every day. I don't have time to do that. So, I will once a month take a look at all your emails and send you a response, and send that back to the homeowner, and really kind of control your job and your obligations and say, look, if it's an emergency and it's a condo townhome type situation where there's a water shutoff, call the emergency phone line. But if it's not an emergency, I will answer you once a month. I'm not going to answer you on a daily basis. I'm not going to take these calls on a daily basis because, again, you're not paid to do that. You have to be available to your homeowners to answer their legitimate questions. But when they're emailing you every single day, that's beyond your job description, and you want to put them on notice that you're not going to do it. And when we get to text, why would you ever give a homeowner your phone number? No. Fine to give it to your board members, but don't give it to your homeowners. There's no reason for you to have to be burdened by text. Tell them to send you an email, and that way it comes through the normal communications line. And the other thing is, by making it come through email, you are going to then have a record of it. When it's a text, it's hard to, you can go buy those programs actually, and we've had to do that when we end up in court, where we have to download all those texts so that we can show the court how burdensome they are, right? You want to make sure that you have a record of it if you ever need to have a record of it, either go to the police or to go to court on a separate situation. But I believe you ever have an obligation to give out your phone number so that they can text you. Obviously they can call your phone number at work, and that's fine. And again, if they start overburdening you, tell them, hi, you're one of, however many, and I'm not going to take a call every single day. Limit it, shut it down. Now on board meetings, remember to use your conduct of meetings policy, okay? Your conduct of meeting policy says that you can limit how many homeowners you'll take at a meeting. There's no obligation to listen to every single homeowner who comes to a meeting. You can limit the number that you'll take. So the first 15, the first 20, whatever time you've allotted for your board meeting, you can limit and always use that 3 minutes. I've seen some boards just get a little clock. Okay, every time somebody starts talking, they start the timer. They're told they get 3 minutes. Again, you have to control your surroundings, and you have the tools to do it. You've got to get your boards to work with you on that, but there's no reason to, take, 30 people, especially if they're talking about the same thing. And the other thing is remember when you're at a board meeting, you don't have to take coarse, vulgar language. Your conduct meeting says they'll be civil and they'll be polite. There'll be no yelling. There'll be no cursing. And if they start doing that, say either stop doing it or you need to leave. And if they won't leave, adjourn the meeting. There's no reason to let them control the community, the hearing or anything by doing that kind of conduct. And that's why you have a conduct of meetings policy, is to stop that. When do you get the attorney involved? Well, again, this is one of those things where you have, kind of two different things that you have to dance around. If it's a homeowner who is complaining because they're getting violation notices, right? That you have to go through your HB 1137 conduct. You have to make sure you've gotten the multiple letters out before you can turn it over to a lawyer to take action on that covenant. But if these aren't covenant violations, this is just an owner who's harassing and harassing and harassing, right? We're not talking about imposing fines. They're just harassing you or the board members. You can get a lawyer involved and say, look, I need you to send them a letter that they've got to stop this. And it's entirely appropriate for you or the board to send out that letter to the homeowner saying, this conduct is unacceptable. This manager represents the entire community and does not have time to babysit you with, multiple emails every day, and they won't. And so if you've gotten to that point and in your emails, you've told them, I can't do emails from you every single day. I don't have the time. I have other communities. I have other homeowners in this community. I have board member duties. I have obligations that I have to do, and I can't take the time every single day to answer your emails. And if that hasn't gotten their attention, turn over the lawyer. Have the lawyer send a letter and explain, we're no longer going to accept emails from you at all. We are going to block your emails. But that requires that you actually do that. That requires the manager and the board members to actually block the email. Because if you keep taking their email, the lawyer letter was a complete waste of money. It's like, telling a child, no, 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 and handing them the candy anyway. Don't do something unless you're going to back it up. So if you're ready, they've not settled down, they've not stopped the emails, they've not stopped the calls, have the lawyer send a letter. Here's what you need to know about that, though. Those fees for the lawyer may not be able to be going back on that homeowner's ledger. Now, if this community is a post-Kiowa community, Kiowa says misconduct that causes an expense to the HOA may be placed back on that owner's ledger. So if they're a post-Kiowa community and you've warned them that repeated emails are overburdensome and you cannot take them and to stop, and they haven't stopped, and you then had to turn over the lawyer, in that community, post-Kiowa community, you can then take the cost of the lawyer letter and put it on the homeowner's ledger. Okay? If it's a pre-Kiowa community, you cannot. If it's a pre-Kiowa community and you got somebody who's just burying you in emails, all you can do is tell them, send it to me snail mail, and I'm going to block your emails. You can have the lawyer letter done, but you can't put the letter cost on the homeowner's ledger. That's just a cost to the association. You will not be able to transfer that back to their ledger. Can you sue? Really going to depend on it. Courts are not happy with HOAs, you know that. And for us to sue the homeowner, it's going to have to mean that there's absolutely nothing valid in those letters, in those emails that are being sent. Meaning there's no request to the manager to fix something. There's no request in the entire email. And you guys are seeing these emails. The emails have, pages of gobbledygook in there. And if there's one valid thing in that email, the judge is going to find that email to be valid. So you're going to have to look at every single email and see if there's anything valid. And if the email is about something that they've been told no 20 times already, and you've sent them letters saying, we've already told you that, stop emailing about it, then that's a valid harassing email. If we're going to make a pile, so we're going to put that in the pile as a valid harassing email because you've told them no, you've told them stop emailing on it, we're not changing our decision, and they keep emailing. You could say that's a harassing email. But if there's one valid point of, and the board should not have hired such and such landscaper because the landscaping looks horrible, the grass is dying, they're overwatering, it's drowning, it's yellow, it's awful. That's a valid email. That's not going to go in the harassment pile. That's going to go in the other pile because homeowners have a right to tell the board, we don't like who you hired. It's our money. It's our community. We don't like who you hired. They're not doing a good job. And so that's going to go in the valid pile. And so you'd have to go through every email. And if you get a pile of emails, that show that we can go to the court and go, look, this is just for the purpose of harassment. They're doing nothing but sending emails and wasting our time with no possible goal, because there's nothing in there for us to even fix or address. Yes, it's harassment. But here's the thing. Okay, they've harassed us. What were your damages? Right? You have to attach the damages to that pile, right? And how many of your managers get to bill separately for the harassment? Right? Most of your managers are paid a set fee per month. And so whether their time is wasted or not, where's the damage to the HOA that they've had to deal with harass email? None, right? So that becomes the next thing, is like going to court on it is very, very difficult. And so, you have to look at things in that regard, okay? This comes up in a lot of my communities, all right? You have the same homeowner who comes every meeting, and every homeowner's forum, she writes down her name, and every homeowner's forum, she complains about the exact same thing. You have the right to say, look, we're not going to hear it. We've already heard it. We voted on it. Next. And really cut her off and say, we're not discussing that again. Do you have anything else you'd like to bring up? And if the answer is no, say, thank you. We're not hearing that again. And go to the next person. But again, it takes a very firm hand. You don't have to be rude about it. You have to be very specific, though. Like in this cartoon, sidewalk cracks. We've heard it. We've already ruled on it. We're done. We're not going to hear it again. And just move on, because it has no legitimate purpose any further. And so you don't have to listen to it. When you look at your board meeting, conduct of meetings, right? It prohibits yelling, screaming, and acting out. So you've already got that in your pocket. If you have a homeowner who's completely refusing to comply with this, you got to call them out. Stop cussing, stop screaming, or we're going to, if it's on a Zoom call, we're going to just mute you. We're not going to take this anymore. So you can either be polite and civil and respect our time and everybody else here, or we're going to just mute you. We're not going to let you talk. If it's in person, you got to be willing to walk. You really have to walk out that door and say, first ask them to leave. Please leave. You're violating our code of conduct. You're ruining our meeting. We have work to attend, and you are not complying. And if they won't walk, you have to walk. Okay? So call them out. If they won't stop, adjourn the meeting. And then next month, hire that off-duty officer to sit there. And if they start it up again, ask the officer to escort them out of the room. Or have it at the police department. And, they start acting up, go step outside the police department doors, ask an officer to come over and remove them. Get them out of there. Make it very clear you are not going to tolerate that, okay? There's no reason for it. If you have, there's a question here. If a board member hinders the harmony of the meeting, displaying offensive and ugly decor in front of the unit, again, there's nothing illegal anymore about any sign of any kind, right? Nothing can be done. The statute is very clear that HOAs have absolutely no control of any kind whatsoever on what a sign says. You cannot control the content. So it doesn't matter what the content is. There is no violation. The statute's clear. And so there's nothing you can do about that. Question also, can you do this on an email? Hi, we've addressed this. We're not going to do it again. I would be on the email saying, we've already answered this question. Please refer to, and I put the date that you did it. Please refer to this email. It's already been answered. Next. Okay. Um, what about, the homeowner that complains about something that nobody else can find, right? And it's a constant complaint. Did you not see that? Did you not see this? Did you not see that? And the answer is no. Sorry, please take a photo. We'll be happy to address it if you can bring us proof, right? If there's no proof of what they're complaining about, it's as if it didn't happen. Okay, what about owners harassing owners? Okay. How often, and I know the answer because I've talked to you managers so many times about this. How often do you have that one owner who is harassing his neighbor or harassing you and trying to get you to deal with the neighbor, right? Like that's your job. Go make him be nice to me, right? Um, the first thing you have to do is evaluate if there's a covenant violation, whether it's parking, dog poop, barking, not on a leash, any of those things. First thing, is there truly a covenant violation? And I have to tell you, 9 times out of 10, the first thing that pops up that you see is the homeowner who's complaining that the other neighbor's rude. He said, blah, 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 blah. And I find that really offensive. Okay, I can't make him be polite. That's not part of covenant enforcement. Sorry. I know it's horrible to live next to a rude person, but there's nothing I can do about that, right? Move on. Don't waste your time. You can't do anything about that. What about, it's a dispute over parking? He keeps parking in front of my house. Well, the new law says he can park anywhere on the streets he wants, and I can't do anything about it. So I'm sorry, I can't help you. If you think it's a violation of the city code, please call the cops. Dog poop, barking, or not on a leash. Feel free to follow our covenant enforcement policy and file the complaint through the system. We'll be happy to address it in that regard. Please make sure that if you're saying that he's not picking up after his dog when his dog poops, that you have photos because he'll claim it's not him. Again, really kind of push it back on the person complaining. Provide me proof and I'm happy to file the covenant violation. Provide me proof of what you're complaining about. And the other thing you need to remind homeowners is that our lovely legislature took away a lot of your controls, right? So unless something happens nonstop for 30 days, you're never going to be able to find them. So if they want to talk to you about a barking dog or a dog not on a leash, tell them their best recourse is to call animal control or the local code enforcement officer and complain about it, because they can go out and issue a ticket today. And you can't do anything unless it continues for 30 days. So again, push it back on them. Tell them to call somebody who can help them, but you're not that person. Okay. Noises, smells, smoke, stuff like that. Again, unless it continues for 30 days, there's nothing you can do. And so you don't have any ability for that covenant enforcement. All right. What about a dispute involving a board member? Well, the reason that's different and gets its own line item is because they don't get special treatment. So if they're the person whose dog is being walked and not being picked up after, it's the same answer, right? Happy to file the complaint, send me proof. Happy to do what I can, but I've got to follow 1137. And or he's got a dog that's barking, call the cops, right? They don't get any special treatment. And you want to make sure that's clear, right? Because you don't want them to claim that, the board gets away with anything. Okay. Obviously, smoking is one of those issues right now that there's very, very little you can do about. With 1137, nuisance violations almost are something that we have no ability to do anything with anymore. They've always been difficult in the past because it's one person's opinion about another person. But now, unless that nuisance continues for 30 days, you're not going to be able to do anything, right? Our hands under nuisance violations it's gotten to the point where unless it's really a threat to health or human safety, so that we can shorten the period of time down to a 3-day provision. And even then, I mean, think about it. I have communities that are on acreage and prohibit guns and shooting, right? And you have the, kids go out there and practice target shooting, even though there's a prohibition against it. Okay, I can have the manager can send a 3-day letter. Hi, this is a violation of the covenants. It's a health and safety issue. Stop doing it. But unless they're target practicing every single day and it continues past 3 days, you're never going to get to a fine. You're never going to get to turnover counsel. And so the nuisance violations really are almost something that there's nothing you can do with. Smoking, smells, those are things that, because of 1137, there's not much you can do at all on those. Again, this type of covenant is something we see a lot, and certainly it talks about unreasonable annoyance. And if you remember the Webster definition, that is the definition of harassment, an unreasonable annoyance. But you really can't do anything with this because, when you're talking about, what's an annoyance to you, what's an annoyance to them, that's the first hurdle when you're trying to prove it. It might only be an annoyance to one person on the floor, not the other 4 people. And so you don't have a good case in court. And again, unless the nuisance continues unabated for 30 days, you can't send a second letter under 1137. So the nuisance provisions of your covenants have almost been gutted. There's not much you can do with them. When do you want to call the police, right? Covenant enforcement issues, if it's a noise disturbance, if it's a barking disturbance, if it's firecrackers, because most of the cities have code and ordinances against them, definitely call the police. Again, your nuisance provisions in your declaration have been almost gutted by 1137. So for our manager, your response to the homeowners calling on any of those kinds of issues is going to push them over to the police because you can't do anything anymore, right? The provisions of Kiowa 209.5, which is what the statute is for the House Bill 1137, it's now 209.5. They've just really gutted everything that you can do. And so often you're going to have to refer people to the police. And what I want to remind you when you do that is, don't say to the owner, this is a neighbor-to-neighbor issue, I'm not going to help you, right? Because what they're going to do with that is send nastygrams back to you that you're refusing to enforce the covenants. What you want to send to them when you get these circumstances is, I understand this is in the covenants. Please understand that the provisions of Kiowa make it such that I can't do anything until this continues unabated for 30 days. So because of that, your best answer to get this to stop is to call the police. Explain to them why you're referring them to police. Don't refer them over there and say, I'm not going to help you. When you have those 2 neighbors that they're fighting with one another and they keep calling you and trying to drag you in the middle of it, your answer is not, this is a neighbor to neighbor. Go solve it with your neighbor. Your answer is, there's no covenant violation for being rude. There's no covenant violation for yelling at you. I can't assist you with that. If they threaten you in any way, please call the police. I can't assist you with that either. Remind them that the reason that you're referring them to the police is because it's not a covenant violation. It's not because it's neighbor to neighbor. Okay. I've seen lawsuits come back against the HOA for failing to enforce their covenants. And the answer I got from the manager every time I called the manager was it was neighbor to neighbor. Well, it's still in the covenants. It is in the covenants. Unfortunately, Kiowa's made it so that we almost can't enforce it. And so, one of the things that you want to do is just look at some of the things you can do, right? Obviously, a lot of the things that we have dealt with in the past about covenant enforcement, we're now going to tell you to refer outside because, again, you're not going to get a quick answer. You're not going to be able to do something. If you have the hoarding issue, you have the person you think is hoarding, that could be a health and safety letter, right? Because you're going to have the smells. The smells are probably easily going to continue more than 3 days. Send the health and safety notice to that homeowner. And if it doesn't get a response, turn over to council. But you can also call the health department on that one and probably the fire department, because if they're hoarding in a situation with shared walls, it's a fire hazard and you're going to be able to get some help there. If in fact it's noise disturbances, it's loud music, it's barking, call animal control, call code enforcement, call the police department on the noise disturbance. It's unlikely those are going to happen for more than 30 days. It's unlikely you're going to find a court to think barking dogs, loud music, noise disturbances are a health safety issue. So you're going to be in that 30-day provision, and so you're going to have to look to other avenues to help you on that. Obviously, water running, the fire department can come in quickly and help you get it shut off if you can't find a homeowner to do so. I think that is a clear safety issue if the water continues to run, because you're going to have mold and you're going to have damage to your building. That's going to be a 3-day issue. But again, you've got to look at each one of these things and say, what can we do? When can we do it? What is our options here? And a lot of times what your options are is you're going to refer people out to someone else, because you're really not going to be able to do anything quickly. Sometimes you're going to have a provision in your covenants that talks compliance with law, right? Nothing shall be done or kept on a property within the community in violation of the law. That ordinance, that's a great covenant, and we can use that sometimes. But what you want to be mindful of is you still have that 1137 provision, right? That still says 3 days or 30 days. Most of the time, if it's a violation of law in regards to safety, will be the 3 days. But okay, you have a tenant. Cops are called constantly, right? And they come to the unit. What are you going to do about it? Well, you can send the 3-day notice to the landlord saying, the cops keep getting called out because your tenant's fighting with his girlfriend. But again, you have to give him 3 days to fix it. And most of the time the cops get called the first night. They either arrest him or they don't, but the conduct doesn't continue 3 days. And so there's not much you're going to do beyond the warning notice to the landlord. Hopefully the landlord will take that warning notice and decide it's not a good tenant. And if the cops are constantly calling, maybe his unit is not safely protected. And because of that, he'll want to get a new tenant. But even with having this provision in your declaration, it's not going to allow you to get rid of him, because again, it's not going to continue for 3 days, right? The other thing we have is sometimes owners get arrested at the property, and the neighbors all go, oh my God, he was arrested at the property. Do something, get him out of there. Well, if he's an owner, there's nothing you can do, because the fact he's arrested at the property doesn't mean he can't own and stay in the unit. So he gets to stay there regardless. And the fact he was arrested in the property doesn't mean that whatever happened in the community. And if it didn't happen in the community, it's not a violation of your covenants. So sometimes there's not much you can do, even though the cops are showing up a lot. It doesn't mean anything's happening. And so sometimes it's just, you have to explain to the homeowners, what HB 1137 did on your ability to help them with their community. What about harassment of association vendors? Okay. Owners have no right to contact your vendors that the association hires, because the association is the one tasked with hiring the vendors to maintain the common areas, or hiring the vendors sometimes to maintain the units. And in fact, often the association is named as the attorney in fact to do this work. And so owners have no right to then walk up to that landscaper or walk up to that roofer and go, you need to do this differently. I want you to do whatever. That is harassment. And it can rise to the level of interference with contract. And that's a separate that's a separate civil action that you can file against that homeowner. If you have a homeowner who is interfering with your vendors, you can have me send them a letter saying, this is a violation. You have no legal authority to contact my vendors. Do not contact them any further. And if my vendors refuse to come back to the job and I have to hire a new vendor, any cost of that is damages that I can seek from you in a lawsuit against you. Stop the conduct immediately. Okay? But we're going to be kind of in that same boat as we were before when I was talking about turning it over to counsel to write the letter to stop harassing the manager or the board, which is, unless you are a post-Kiowa community, there's no authority to put these fees back on that homeowner's ledger. Now, there are rarely, there may be something in the covenants that say if a homeowner causes an expense to the community, and it might be in the declaration to give you that authority, but it's really pretty rare to see those kinds of provisions in pre-Kiowa communities. So mostly the only time you're going to be able to put this kind of fee back on a homeowner's ledger is, again, if in fact you're a post-Kiowa community. All right. What about if you have one homeowner harassing another homeowner? This is important for you to realize that if this kind of thing happens, you have a duty to step in and send a letter. All right. FHA came out many years ago and said that HOAs have to take any steps they can to stop discrimination. So if you have one homeowner come to you and say his neighbor called him all kinds of racial epithets, you need to send a letter to the neighbor saying that conduct is not tolerated. I get it. It's not your job to tell him to be nice. It's not your job to tell him not to say those. But FHA said we have to try. So we're going to try. We're going to send him a letter that says, don't do that. It's not tolerated. At the same time, I recommend you send a letter back to the owner who got the racial threats and say, if you're being threatened, call the cops. I can't stop threats. If you think it's a hate crime, call the cops. I can't stop that either. I'll be happy to send him a letter, but understand I really have no authority to stop this kind of conduct, right? It is an absolute bluff. I'm going to do my best. I'll make it a firm letter. I'll be as firm as I can, but there's nothing I can do about it. Okay. So you need to make sure that you tell kind of both parties, the one doing the bad act, stop that. And the one who is being threatened, it's a bluff. There's not much I can do. Okay. I think if you do nothing, you're going to run into some problems. But I think you need to just do your best. And because that's all you can do. I don't think any of you got this, did you? This wasn't on any of the ads you saw, right? But it's what your board members expect, and it's what your homeowners expect. And a lot of your job in dealing with harassment is explaining how all of this is really not your job. And a lot of times all of this is what they want and expect you to do. And you need to, a lot of your job is going to be to explain to them how it's not your job. I generally don't think I need to say this, but I'm amazed at how many times there are threats, and the HOA board is saying, call the lawyer. No, call the cops. If it's a threat, they're threatening anybody, whether it's a board member, another owner, another manager. If it's a threat of any kind, there's weapons, there's blood, there's damage, there's fire. Don't call the manager. Don't call the lawyer. Call 911. After the fact, then, you can call your lawyer afterwards. But step one, call 911. Remember, there's no duty of you, the manager, nor your board members to step in and protect someone. There's no duty of you to try and stop the fight. There's Good Samaritan laws in Colorado that says if you do step in, it tries to help you from not being liable if you can't give aid when you're trying to stop things. But there's no duty to do it, okay? When there's threats coming in, when there's crime in the community, that is not your job. Many of the homeowners think that if in fact there's criminals moving in, you have to tell all the homeowners. Again, not your job, okay? If homeowners find out there is a sex offender, he's registered, he's moving into your community, not your job to tell them and put them on notice, right? Your job, if somebody calls you and says, hey, there's a repeat sex offender moving into the community, you need to tell everybody, say, I'll be happy to put the link of where people can search for that information on the website. But I don't have time to manage it. I don't have time to make sure it's not happening, and I can't make sure it's not happening. And if you were to try and take it on and then you miss somebody, they could sue you and say, I relied upon you to let me know, and you didn't, and I was injured, so it's your fault. Don't take on obligations that are not yours, because it just creates liability. Lots of threats. lots of the threats that come into board members, lots of the threats that come into the manager are nothing more than bluff. And some of them are, I have a lawyer. I'm going to call my lawyer. Those we can ignore and laugh about because whatever. Okay, call your lawyer. I don't care. Here's my lawyer's name. Have him call them. I don't care. But when it's a threat of harm, I don't think you should be bluffing. If you have someone threaten you, call the cops, right? Whether you think it's an empty threat or not, again, you don't want to be the person who's being injured because you thought it was a bluff and it's not, right? There's a lot of threats made, most of the threats that I get are, I'm going to get you. What does that mean? I'm going to make sure that the HOA is disbanded. Give it your best shot. I'm going to make sure that you're fired. I'm going to make sure you're not elected. None of those threats are anything that you can do anything about. But if it's a threat of harm, that's a 911 call. What about the board member? You ever had the board member who's threatening other board members? That's that point in time where you want to call your lawyer for the association and go, I need you to come to a meeting and explain, bullying one board member against another board member is not appropriate, right? And you actually have to play like the parent and say, hi, this is not appropriate. And this is what happens if you start doing these things, okay? Those kinds of things, again, get to be a point where sometimes it's very quickly outside of your hands, which is any threat of harm, immediately out of your hands. If it's in writing, and again, the threats of harm, you want to call the cops and give it to them. At a minimum, most cops will go over there and talk to them and say, if you even think about doing this, you're going to be arrested. Even if it's just spoken to you, you can tell the cops and they'll come, if the threat is of harm, the cops will intercede. If there are physical threats, sometimes what you want to think about doing is getting a civil protection order. And I'll talk about that really briefly in a moment. But again, you don't have authority to protect homeowners from threats of harm. That's a police authority, right? You need to remember that your authority is about the HOA. And so when you're talking to homeowners and there starts being threats thrown, say, look, whoa, you start making threats, I'm just going to call the cops because that's not mine. And we're not accepting that. We're not tolerating that. When you're talking about a restraining order, it's now called a civil protection order. Okay. And when can you get one? There has to be a threat of imminent harm. If the threat is that they're going to harm a board member or they're going to harm a manager, you need to think about who can get the restraining order. The statute says that a boss can get a restraining order for their employees. So if it's a management company that's being threatened, the CEO of the management company can get a restraining order to protect all of his employees. An HOA cannot get a restraining order for anybody because an HOA generally has no employees. So if there's a threat of harm to the board member, the individual board member has to get the restraining order for themselves. Can they get the attorney to pay for it? Can they pay the attorney to get it for them using association money? I'll say that right in a minute. That depends on their covenants. You're going to have to look at the documents. Do you have authority in the documents to go get that civil protection order for that board member using association funds? Depends what it says the assessments can be used for, right? Can you put the cost back on the homeowner? Not if they're pre-Kiowa most of the time. If they're post-Kiowa, generally you can. But again, that's because it's misconduct. They're threatening to harm you. But you have to look through that and you have to take a board vote to use the funds. So just you get one homeowner who comes and threatens the board member, that board member then doesn't get to unilaterally decide to hire the lawyer to go get the civil protection order. Board vote, it's going to happen. And again, if you're post-Kiowa, then you can probably put it back on that homeowner's ledger. But again, you have to make sure that you go through the proper steps. Remember that when you're getting a protection order, it's because somebody threatened to beat somebody up, right? The communications could be a physical threat, like you've got a really big guy and he makes a fist and he's standing right, like, I'm going to punch you. And he may not say the words, but he's making the physical action, and he's making it very clear by those physical actions, and he's purposely trying to intimidate you. Those are times that you can get a restraining order. Again, I will tell you, the process is meant to be utilized without an attorney, because it was developed for victims of domestic violence who don't have attorneys. And so the paperwork are all pre-printed forms. You check boxes, fill things in, and they're made to be simple so that you can go get one without having an attorney. But you have to prove there's a threat of harm, and it has to be an imminent threat of harm. Okay. What do you do with the owner versus owner dispute over parking? Well, we used to be able, to say, well, file the complaint and we'll take care of it. But if the dispute is in the city streets, we can no longer take care of it, because the HOA no longer controls parking in the streets. Owner by owner dog poop, barking on leash, we kind of covered those already. Those are those issues that, again, HB 1137 made it impossible for us to deal with. And remember, fair housing is something that, it makes it very ugly and very difficult to deal with, because now we're going to try and write a letter that we really aren't going to be able to back up, and we're never going to get to fine. But be aware of that. One circumstance you can deal with, and not everybody knows it, is if you have that homeowner who says they have a service dog or says it's an ESA and that dog tries to bite somebody. It is not reasonable and not required under the Fair Housing Act for you to allow an owner to keep a dog that threatens to bite. Okay? So even if they claim it's a fair housing dog, whether they claim it's an emotional support dog or a service dog, if it tries to bite someone or another animal, you can demand that dog be removed. Okay? Get another dog, but you can't have one that's going to threaten to bite. Okay? Sometimes what we see is threats and harassment by renters. Remember, as managers, you don't have to take any of those letters, any of those emails from your renters. Tell them to talk to the owner. Not your problem. Tell them to call somebody that they're in what's called privity with, which is the person they signed a contract with. So the renters, tell them to call the landlord. Again, when you're talking about crimes and the threat of crimes, you want to make sure that the crimes are something that are happening in the community, so you actually have some control over it. If it's not something happening in the community, then it's not anything you have control over. If they're telling you that there's crime happening in the community, you need to be asking them questions of, do you have proof? Have you called the cops? Most of the time what they want is they want you, the manager, to call the cops. And you want to tell them, cops aren't going to listen to me. I didn't see it, right? If you saw it, you have reliable information, you need to call the cops. You need to tell them what you saw, because my information is hearsay and the cops won't do anything about it. It has to come from the homeowner or the person who saw it, right? Before the board takes any actions, you get homeowners all up in arms. Do you have any authority to take action? Do you have proof of it? Do you have a covenant enforcement you can enforce? Have you followed all the steps that are under 1137 to enforce it? Or is this something that's completely outside your authority? There's nothing in your covenants about it. Yes, it's horrible. Yes, it's a crime, but it's nothing you have authority. And then you're going to refer it back to the proper person, right? You have to go through each of those. For the police, they're going to get all of these things now, because all of it is outside of your, authority for the most point. Noise, you're not going to be able to do anything under 1137. Threat of violence, you don't want to do anything anyway. Towing has been severely restricted by the tow bill. Occasionally, you're going to be able to tow, but most of the time, you're going to love to turn over to the cops if you can, because then it takes you out of that chain and the obligations of the new tow bill. So if it's in the fire lane, call the police, have them come tow it for a fire lane. Take yourself out of that equation. Any threat of weapons, it's not yours. Harassment, if you can give it to the police, one, they might be able to talk them down if it's that harassment that's threatening. And even if it's like, the daily or multiple times a day kind of harassment, sometimes they can just go talk to them and stop the emails. Remember, on the car crash on HOA property, make sure that the cop lists the HOA as a victim. If you're listed as a victim, you get notice of the restitution hearings. You're going to have that DA fighting for your money back in, rather than you having to sue somebody who may not even live in your community. Animal bites. That one's one that's going to be a threat. That's a 3-day letter. But again, cops can act now. They don't have to wait. Remember, managers, you're going to get treated like a landlord. Cops don't know the difference. They're going to ask you for things. If you don't think you have a right to do it, call your attorney and say, can I do what the cop wants? Should I be getting them to give me a subpoena or something else? Make sure that you're not exceeding your abilities to disclose information, and make sure you're not giving them things that you wouldn't give to a homeowner. Again, talk to your attorneys about this so that you're making sure that when they're treating you like a landlord, you're trying to explain to them, I'm not a landlord, I'm a manager of a community. I don't own the property, because it's a big difference. We're almost out of time, so let me try and go through these questions because I know there were a bunch of them. If I can get my mouse to help, and I'm not getting any help. There we go. Okay, let's see if I can get through these questions. What are the consequences of a board member being the one harassing a homeowner? Is there information in CAIO about that? No. If you have a board member who's harassing your homeowner, what you want to talk to them about is that conduct probably isn't covered under their insurance policy because they're acting outside the authority of a board. Whenever you have one board member going rogue, remind them that their protection under the law comes from board votes. And if they're on their own solo acting, they may not have authority and they may not have insurance protection, right? Because the insurance protects board action. And if this is one homeowner acting on his own, acting rogue, he's probably not insured and he could risk personal liability for his actions. When is signed content considered harassment? To the HOA, never. HOA has absolutely no control over signed content. So if you have a homeowner who thinks the signed content is actionable, tell them to call the police because it's not something the HOA can do about. Smoking is nothing the HOA can take notice on because, again, you're never going to hit past that date unless the smoking continues nonstop for 30 days. Then I guess you can call it a nuisance and try and take action on it. But for it to be a nuisance, you're going to have more than one. My recommendation is you need at least 3 owners to file a nuisance complaint. So if you have something and they're smoking every day nonstop and the smoke's bothering them every day nonstop for more than 30 days and you got 3 people willing to take action, you can go forward with a smoking complaint. Is the manager or the HOA responsible for notifying the owners of a bad tenant? HOA only wants to be notifying a landlord of a covenant violation. The definition of bad tenant is not yours to make. Your only responsibility is if there's a covenant violation in that unit, you send the letter to the owner, not to the tenant. Those are the only letters you should be sending to a landlord. If you exceed that, you could be the person who's being accused of tortious interference with a contract. Is there a legal term that can be used to describe homeowners who reach out to vendors? Again, it's tortious interference with contract because they have no right to contact them. Do we state who complained in a letter? If you're sending that FHA letter to somebody for calling names and making racial epithets, you're going to have to say who they made the complaint or who they called out, right? If neighbor A called like neighbor B all kinds of racial terms, you're going to have to say, dear neighbor A, do not call neighbor B these names. It is unacceptable conduct. We will not tolerate it in this community. We will take all legal steps we can to fight it. That's all you need to say. When a homeowner states they have an attorney multiple times, can we tell them that the attorney needs to communicate with the HOA attorney on future communications? You can't force it. You can say, look, if your lawyer contacts us, we'll be happy to forward it to our attorney. That's all you want to say. Look, if you really have you don't want to say if you really have an attorney, just say, look, send us your letter. If you want your attorney to send us a letter, we'll forward it to our attorney to answer. You don't get to refuse to talk to them because they claim they have an attorney. What do you do on parking when the police won't come onto a private road? If it's a private road, you still have enforcement abilities. So you're going to have to do covenant enforcement on a private road. But here's your problem. Your parking violation is going to happen. You're going to send the violation letter. And they're going to move it probably within a day. So you're never going to get to your 30 days. Now, if they park in the exact same spot 30 days in a row, you can probably turn that over and fine them, and then work on the next 30 days. And if they continue to do it nonstop for every day for the next 30 days, then you can turn it over to the lawyer. But if they miss one day in that 60-day period, I think you will not be able to legally turn it over to the council under HB 1137. If smoking comes under 1137, how if HOA makes their community a non-smoking property, how do you deal with that? And non-smoking, even if you have a covenant that says you can't smoke in this community, that's the same as any other covenant. Under 1137, the violation has to be nonstop for 30 days to get the fine, and then nonstop again another 30 days before you can turn it over to the lawyer. So even if it's a non-smoking community and they smoke nonstop for 60 days, then you can turn it over to the lawyer, and not before under 1137. What happens if tenant reaches out and you start talking and then it gets out of hand? Can you tell them that they need to address the issue with the owner? Anytime you're having any communications with a tenant, the owner can claim that you're interfering with the contract. If you have lots of tenants in your community, you want to look into working with your lawyer to have an addendum drafted that basically the landlords sign that says whether or not the manager can talk to their tenant or not. Because that way, if a tenant contacts you, you can respond back to them. If you don't have something like that, then every time you talk to a tenant, you're risking a situation where a landlord is going to accuse you of tortious interference. There's just nothing you can do to stop that. In regard to parking, if they're parking on the HOA privately owned roads or guest parking spaces, the 30-day rule still applies even if we have different guidelines in your rules? Yes. 30-day rules still apply. You cannot fine anybody unless they've been in violation for 30 days. Cannot. 1137. It's a horrible provision, and it's still what it is. So, at this point, you have to follow it. Can you still tow? Your tow has to follow the provisions of the tow bill. The tow bill is notice first time, notice a second time. On the third time, you can tow. If you follow those provisions and you're appropriately signed, then yes, you can still tow. There was a lot of slides we had to skip because I ran out of time. I'm sorry about that. The bottom line, folks, don't take on obligations that aren't yours. If you're being threatened, call a cop. Don't deal with it. And on harassment, again, point it out to them first. If they don't come into, stopping the harassment by emails or calls, turn it over to the lawyer. But understand, you may not be able to put the fees on their ledger. The towing reference was HB, I want to say 1314, but I don't remember the statute off the top of my head because it's not in Kiowa. It's in the vehicle section of the statute, so it's in Title 42. If you email me, I can send you a copy of the bill, but I don't remember the statute off the top of my head. I'm so sorry. And we are out of time, so thank you everybody for all of your questions and all of your comments, and have a great afternoon.